This first case wastes no time showing the thin line between defiance and consequence. Warren Mills faces a serious second-degree felony for assaulting a peace officer, a charge that instantly raises the stakes. The judge's tone is firm yet controlled, balancing justice with procedure. But behind every yes ma'am, you can almost feel the weight of regret settling in.
Good morning. Are you Warren Mills?
Good morning, yes, ma'am.
Will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Mills, in cause number 25 DCCR 0082, you're charged with a second-degree felony offense of assault on a peace officer from November 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
I understand it.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am, I understand.
State tenders number
No
1.
objection.
It's admitted. Any evidence that Mr. Mills is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of that plea.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time, find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal.
Yes, ma'am.
I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices
ma'am.
qualify. I have to read the whole thing to you.
Oh, yes, ma'am.
That's okay. That's okay. And see, now I'm going to mess it up because I got. No, you're fine. You should just. That's okay. Just read it to make sure you understand what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Just for the record, Judge, I believe Mr. Nichols has agreed to dismiss his misdemeanor case in County Court 2.
We have.
Okay.
Okay, then I'm sure Mr. Nichols will take care of that, and they'll that way you'll be able to not have that holding you out there anymore. Okay.
That's good.
On that,
All right.
on that
Good luck
judge
to you,
case,
sir. You can go back with
Thank
the
you very
bailiff.
much.
Next up, Robert Tran steps before the bench, a name that's become too familiar to the court docket. With prior convictions ranging from evading arrest to possession, his new charges carry a heavy echo of past choices. The tension here isn't about guilt, it's about whether he's learned anything at all. A Houston lawyer might buy him time, but not mercy.
Good morning. Are you Robert Tran?
Yes, ma'am.
And Mr. Tran, in cause number 25 DCCR 1094, is charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. That indictment alleges a prior offense of accident involving injury or death on October 16th of 2017. And then after that was final, convictions on October 17th of 2022 for evading arrest or detention with the use of a vehicle, and also possession of a controlled substance, a second-degree felony, making this, if all of that's true, for punishment purposes, a second-degree felony offense. And then in cause number 25, DCCR 1317, charged with possession of a controlled substance. Let's see. Also a state jail felony, has those same prior offenses listed, convictions listed again. For punishment purposes, that would make this a second-degree felony offense, if true. And what is the announcement?
Your Honor, he's instructed me that his family has hired a lawyer out of Houston to represent him, and I don't think he's had time to file with the court, and so I asked that it be reset for him to make those arrangements. That's what
Okay.
he told me.
So whoever that is hasn't filed anything yet to show that he represents you. And so what I'll do, Mr. Trahan, is reset your case, a normal reset, which is about 30 days or so. Mr. Parker will remain on until we get that information from that attorney. If for some reason that didn't work out or something didn't happen and he wasn't hired, then Mr. Parker will remain your attorney at that point, okay? All right. Yes, sir. You can go back with the bailiff.
And finally, we meet Kaylin Salazar, a probationer caught in the tangled web of relapse, repeated DWIs, and a pending assault case. What began as a reduced charge has spiraled into a sobering reminder that probation isn't freedom, it's a test. The judge's patience wears thin, yet there's still a faint thread of compassion beneath the discipline.
All right, you're Kaylin Salazar. And Ms. Salazar is on probation in cause number 24, DCCR 2234. And that is for a misdemeanor offense, or a case that was reduced to a misdemeanor. It's an unadjudicated probation. She was placed on that probation April 21st of this year. And it was a criminal mischief that was reduced to an attempted criminal mischief. A motion to revoke has been filed, or motion to revoke unadjudicated probation. It alleges a DWI from August 23rd of 2025. It alleges a failure to report in August, failure to perform community service, behind in court assessed fees, that she admitted to using alcohol in violation of her probation, August 23rd of 2025, that she has not completed a cognitive thinking class as ordered. And in addition, we have a pending felony case of assault on a peace officer with an offense date prior to her getting the probation in this case. And so that's not alleged, and it's standing, I guess, on its own at this point. Mr. Kemmler has filed a motion asking that I set a bond in the misdemeanor probation case where she's on an unadjudicated probation. Mr. Nichols, what's the state's position on that?
Your Honor, in addition to the two cases before you, she has two separate DWIs that are pending lab results that have not yet been filed. One is from March and predates this probation. One is from is what's listed in the motion. It looks like the only thing holding her is the bond on this case, and if she's in light of those arrests and what's alleged in the motion, if she's going to be granted a bond, I ask there be interlock. And
I would suggest she not be allowed to operate a motor vehicle, period, instead of an airline. If she does have the airline, I don't think she needs to be at all. But she wants to go into rehab, Your Honor, and that's really the purpose of me trying to get her a bond. Where have you talked about?
Well, and here's the thing, you don't get to pick all of that. She's on probation, so that has to go through probation. In addition, we have another case pending that, depending on the length of everything, I'm not just going to put off. And so obviously if there needs to be some rehab, then I'm all for that under the right circumstances. But if you make a bond, you can't just go off somewhere without it being approved by probation and ultimately by me, so that we know what that is, where it is, and what that means with regard to that assault on a peace officer case.
It was just, that's her intent. She does recognize that she has an alcohol problem. I've talked to her extensively about that.
Hold on a second. So, Mr. Nichols, any other input?
if it's not going to be, and I agree that maybe her not driving at all is probably the best course, but there needs to be some sort of monitoring, like a SCRAM or something along those lines, Your Honor.
I agree. So what I'm going to do, Ms. Salazar, in cause number 24, DCCR 2234, is to grant that request for me to set a bond. I'm going to set the bond at $10,000. Condition of that bond is you are not allowed to drive anything, no vehicle, period, ever. You will be required to wear a SCRAM device. Obviously, if that tests positive for alcohol, then you will be in violation of your bond conditions. That bond's going to get raised, and you'll be able to wait all this out while you're in jail while it gets sorted out. Do you understand? Any other conditions that?
I think that should cover it, Your Honor.
Okay, and so what I'll do then is we'll reset, a normal reset, and see what we need to do on this, obviously, as well as the other pending felony.
And then she needs to report to her probation officer as soon as you make bond.
Yeah, you're still on probation, so go straight to your probation officer, talk to them about what you need or can do, and then go from there. Okay.
And stay in touch with your bond.
Across these three cases, the courtroom reveals the full spectrum of human accountability. Warren Mills' story begins with violence against an officer, a line that Texas law treats with zero leniency. Yet what stands out isn't just the sentence, but the ritual of justice itself, the calm, repetitive confirmations, the formal yes ma'am, the acknowledgement of lost rights. It's a moment where authority meets admission, where the court's discipline replaces personal control. Mills doesn't argue, he accepts, and that acceptance, though silent, speaks louder than any outburst could. Then comes Robert Tran, a revolving door defendant whose criminal history paints a clear picture of cycles that are hard to break. His case isn't dramatic in tone, but quietly tragic in context. Every reset, every hired lawyer, every procedural pause reflects a man stuck between accountability and avoidance. It's not just about stealing a vehicle, it's about running from responsibility. The judge's patience is methodical, not emotional. This is the kind of justice that moves with process, not pity. But it's Kaylin Salazar's situation that captures the most human conflict. Addiction, probation, and relapse collide in a single courtroom appearance. The judge's struggle is evident, balancing empathy for her attempt to seek rehab against the need to enforce structure. The ruling, a $10,000 bond with strict conditions and an alcohol monitor, feels like both punishment and protection. It's the justice system's paradox, harsh enough to deter, structured enough to save. Salazar's downfall isn't just legal, it's deeply personal, a mirror of how one bad decision can multiply into many. Together, these cases form a powerful portrait of modern courtroom reality, where every defendant's good morning hides a story of struggle, defiance, or surrender. Judges are not just interpreters of law, but guardians of balance, balancing compassion against consistency and consequences against second chances. Each verdict echoes a question for the audience: how much of justice is punishment, and how much is redemption? Can the system reform without compassion, or does mercy sometimes compromise order? If you found these cases as shocking, thought-provoking, and revealing as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns only here, where justice meets reality.